since my name had already been approved and it already gotten approval from the Honorable High Court, so it's like I was left to no other options but to say yes, and I was left to no other options. I was left with no option to back out. So I've tried my best because in any case, since we're all familiar faces, we've known each other. So let's more or less, because I've done a little research and made some time to make some PowerPoint presentations as well, so that it becomes easier for you all as well, because it might not be too it might be a little tedious actually, a little cumbersome. So I thought case laws can be related to related to this particular subject. My PowerPoint presentation one answer, right? So based on that, I'll run through these PowerPoint presentations, and then not exactly sticking to what the program schedule is, because it doesn't make any sense, because the program schedule is only 3-4 parts per answer, but more or less consolidated, it's going to be the same. So it's going to be so that it's not repetitive. Presentation banana, then certain case laws, which is some of the case laws relating to how electronic evidence is to be dealt, and going up to the latest that's been delivered in the year 2000. And likewise, subsequent to that also there are a couple of judgments. In fact, the latest being one passed by the Honorable Supreme Court, setting aside the judgment of the Karnataka High Court. This is with regard to your Karnataka blast pool case now, wherein the court has extensively dealt with whether, although judgment is heard 2000, Pandit Rao judgment is heard, but then too still there's a lot of confusion and there's still a lot of there's no clarity. Although Pandit Rao Kole, have dealt with several of the judgments which were already decided, consolidated waste outcome this, but then too still there seems to be confusions in the court. So this latest judgment, 2023, where the Supreme Court has said that this basically deals with at what stage can the certificate be obtained. At the stage of trial, Karnataka High Court had refused because they said charge sheet file with the file with China. So you've lost that opportunity of filing it because the accused is going to be prejudiced. But the Supreme Court said nothing will. Even during any stage of the trial, before the arguments, the same can be placed on record, and this validity obviously will be examined by the court, and the accused will also be given an opportunity to cross-examine. So therefore, no prejudice will be caused. But of course, but even when the certificate is being put on record, exhibit will now vary. It has to see whether those proper norms mentioned on the section 65B has been followed or not. Whatever the court has allowed. So that's the latest in terms of section 65B like deal going to go. We'll run through that as well, right? And so let it be more of an interactive thing, because more actually you guys are dealing with on a regular basis. Because on a regular basis in the courts you're dealing with it as public prosecutors. So let this be an interactive session, because not just from my sharing my point of view or my little research that I've managed to do, but from your end as well, so that if it's an interactive thing, it's two ways. I also benefit from this training program, not just as a resource person, but as I gain some knowledge from you all as well, because of your experience in the court as public prosecutors. Having dealt with these kind of cases on a regular basis. In fact, my case in terms of one was that MG Mark, where a person was stabbed and the entire footage was captured in the CCTV footage, 307 Mark, but some of discrepancies in 1665 discrepancies in that, I could take advantage of that and I could have my time up with it. But at the same time, on a regular basis you're dealing. And because my operation over the years, my functioning will just be that of a defense counsel throughout my career, because I will never be on your side. Why should I only disclose today everything our defense could disclose? So let this be an interactive thing, right? Let's go. So I'll start with I'll start with it. Let's make it a very good issue.
There are certain stocks which individually owners you have to have something called an institutional account. So through those institutional accounts run by these big companies, you can buy stocks. And the individuals can use of the But it can also what is happening through institutional accounts, using this stock in the money. So it shoots up. The market goes up. And the I got trapped into their ways. Only institutional account, through institutional accounts, I started buying stocks. Well, I say 3,50,000, this is on that. And 50,000, some amount I could withdraw. Got the within a week or two, so they are just to put in the stock. Then I realized when I was trying to withdraw my profits, they were not allowing me to withdraw. They were not allowing me to withdraw. Even these bank accounts, then I realized that the stock market, all these bank accounts, some are in Bengal, some are in Maharashtra, different bank accounts. Different bank accounts. Then I filed a cyber fraud complaint also with the national portal. They forwarded it here. So these are the cumbersome processes. I give up. Now being a lawyer, if I thought about giving it up, I give up. So that's how then I realized it's not necessarily that people who are one for Postiwala, get a vision of what I go, what the victim is. So today the world is advanced. Forget it, even the high end, the mighty educated, me, a person like me who knows at least a little bit about cyber law, who studied law, who's a lawyer by profession, doing these kind of awareness programs. I was a victim. It's like, today when I sit and but at the same time, not to talk about it is also and at the same time, what I think as public prosecutors, for you all also, case it is not a very easy case like you're dealing with your normal cases. These are difficult. First of all, the investigation, because a lot of technicality involved. By the time it reaches your table, there are a lot of rules which the defense take advantage. And I think judgment, still I think as public prosecutors, you will still on a regular basis be facing these problems on a day-to-day basis. With every new case, there will come up new, what do you call that? It's not that complete. No matter how many trainings you attend, you might have a basic idea of how to deal with it. But with every ways and with the advancement of technology, every day technology will advance. You are bound to face issues. Now you cyber crime go. Let's just see a little bit about the history of cyber laws in India. The main act is the Information and Technology Act, which is an outcome of the resolution dated 30th January 1997 of the General Assembly of the United Nations, which adopted the model law of electronic commerce, of international trade law. This resolution recommended inter alia that all states give favorable consideration to the said model law while revising, enacting new laws so that uniformity may be observed in the laws of the various cyber nations applicable to alternative paper-based methods of communication and storage to information. So therefore, the Department of Technology in July 1998 drafted the bill. However, it could only be introduced in the House in December 1999 when the new IT Ministry was formed. It underwent substantial alternation with the Commerce Ministry making suggestions related to e-commerce and matters pertaining to World Trade Organization. The Ministry of Law and Company Affairs then vetted this joint draft. Then finally, the Union Cabinet approved the bill on May 13, 2000 and on May 7, 2000, both the houses of the Parliament passed the Information Technology Bill. The bill received the action of the President on 9 January to June 2000 and came to be known as the Information Technology Act 2000. The Act came in force on 17 October 2000. Then obviously with the passage of time, technology developed further and new methods of committing crimes using internet and computers surfaced the need. Therefore, the need was felt to amend the IT Act of 2000 to insert new kinds of cyber offences and plug in other loopholes. Like we said, first the Act came into existence, but it's every with every development in the use of technology, you think even the Act has been keeps on being amended, right? And this led to the passage of the Information Technology Amendment Act 2008, which was made effective from 2009. You know? Now let us look at the statutory framework of Information Technology Act. The total, just to brief me, it has total 13 chapters, 90 sections, so and so, right? And the object of the Act is the Information Technology Act defined is as under. To provide legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communications, commonly referred to as electronic methods of communication and storage of information. To facilitate electronic filing of documents to the government agencies and further to amend the Indian Penal Code, the Indian Evidence Act 1872, the Bankers Book Evidence Act 1891, and the Reserve Bank of India Act of 1934, and for matters connected incidental thereto. The Act extends to the whole of things. I don't think this has any place. Highlights of the Act. Let's just go to the highlights of the Act. Chapter 2 of the Act specifically stipulates any subscriber may authenticate an electronic record by affixing his digital signature. It further states that any person can verify an electronic record by use of public key of the subscriber. The Act details about electronic governance. I don't think this is also a requirement, right? But we can just run through this. I think this is important. Types of cybercrime for us to understand. Cybercrime can be basically divided into 4 major categories. Crime against person. What is crime against person? Crime committed against person includes various crimes like transmission of child pornography, cyber porn, harassment of a person using a computer. Now I think even social media platforms like Facebook, Instagram and all are taking it very seriously because Meta has now, in fact, tied up with a lot of organizations, especially in the Northeast. In fact, just 1 week back, Mero office name, I had this organization named Hope as well that was registered way back in 2008, wherein we work on issues related to human trafficking, women and children. So during our spare time, we go to places, schools, villages, awareness programs, on different subjects. So they requested, we have a partner organization, so Impulse NGO Network in Shillong. It's an internationally renowned organization based in Shillong. So Meta has tied up with them, and Meta is taking it very seriously because on online safety. So in fact, अस्तिको हप्ता भन्दा पनि 27 तारिकदेखि 29 तारिक 26, 27, 28 मा we hosted a program for all our partners from the Northeast. So Northeast states, including Siliguri organization, we had a 3-day training program, and it was an online safety. Where we basically checking whether online bullying, cyberbullying, sexual content is being posted on thing, children being lured into sexual abuse, training. So even these online platforms are taking it very seriously now. They're upgrading their software to see that reporting of these kind of cases are easily reported and immediately action is taken. Even companies like Meta is taking it very seriously. So one of the main is cybercrime committed against person. Cybercrime committed against person is anything to do with individual, like the potential harassment via emails, cyber stalking these individuals, defamation. I think a lot of this, most of the cases which are reported against Facebook users, Instagram users are BCS to it's like defamation, political defamation, defame, and most of the cases reported, I think, defamation, right? The hacking is also against an individual. Cracking, email spoofing, SMS spoofing, cheating and fraud, child pornography, and assault by threats. It refers to threatening a person with fear for their lives or their family through the use of computer network, email, videos, phones, messages. Cybercrime against property. The second category of cybercrime is cybercrime against all forms of property. This crime includes computer vandalism against property, but which is who will be using a computer. Today, I virus pathaera, I hack into your, not exactly hack, I destroy your thing. Or banking sector is not so. Those were some of the first cases which were reported in India as well. Banking sector, the health sector, the entire system was crashed all over India. The health software hacked the virus pathaera, the entire, all over the country, the entire health system crashed. So these are things against property, right? Then cyber vandalism, hacking computer systems, transmitting virus, cyber trespass, internet time thefts. Basically, internet time thefts comes under hacking. It is the use of an unauthorized person of the internet as paid for by another person. Wimbo Wi-Fi is discreetly, if I log into your thing and without your thing, that would also amount to theft, internet theft. Cybercrime against government. Now the third category of cybercrime relates to crime against government. Cyber terrorism is one distinct kind of crime in this category. The growth of internet has shown that the medium of cyberspace is being used by individuals and groups to threaten the international government as also to threaten the citizens of a country. This crime manifests itself into terrorism when an individual cracks into a government or military maintained website. The parliament attack in Delhi and the recent Mumbai attack fall under this category. Cybercrime against society at large. What is cybercrime against society? An unlawful act done with the intention of causing harm to the cyberspace to affect large number of persons. The offences include child pornography, cyber trafficking, online gambling, financial crimes, forgery. Right? Along with the IT Act, some of the parallel provisions of the IPC and IT Act are hacking and data theft, like Section 43 and 66 of the IT Act penalize a number of activities ranging from hacking into computer networks and so on. In Section 42 of the IPC, 424 of the IPC, some related sections are Section 425 of the IPC. Statutory provisions to deal with these are Section 3. I think Section 3, the definition of evidence as given in the Evidence Act, the evidence of witness, that is oral and documentary evidence, which includes electronic records produced for the inspection of the court. Section 3 of the Act was amended and the phrase all documents produced for the inspection of the court was substituted by all documents including electronic records produced for the inspection of the court. Regarding the documentary evidence in Section 59 for the word contents of document, the word content of documents or electronic records have been substituted and Section 65A and 65B were inserted to incorporate the admissibility of electronic evidence. After the amendment, Section 65A and Section 63 65B to cover electronic evidence inserted in the evidence. And the section 17, admission defined. Section 17, the definition of admission. Section 17 of the Evidence Act has been changed to include a statement in oral, documentary, or oral and documentary after the amendment, or electoral form which suggests an interference to any fact at issue or of relevance. Then the other section, relevant section, would be section 22A. When oral evidence as to the contents of electronic records are relevant, new section 22A has been inserted into the Evidence Act to provide for the relevancy of oral evidence regarding the content of electronic records. It provides that oral admission regarding the content of electronic records are not relevant unless the genuineness of the electronic records produced is in question. So remember, until the evidence's admissibility is in question, none of the corroboration that you provide about its genuineness alone is going to be valid. Section 23, entries in the book of accounts, including those maintained in an electronic form, regularly kept in the course of business. Section 35, an entry in the public or official book, register or records. Section 39, what evidence is to be given when statement forms a part of conversation, document, electronic record, book, or series of letters or papers. When any statement of which evidence is given forms a part of longer statement or of a conversation or a part of an isolated document, or is contained in a document which forms part of a book, or is contained in part of electronic records or connected series of letters or papers, evidence shall be given of so much and no more of the statement, conversation, document, electronic records, book or series of letters or papers as the court considers necessary in that particular case to fully understand the nature and effect of the statement and not of the circumstances under which it was made. Section 45A, opinion of examiner of electronic evidence. When the proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in a computer resource or any other electronic or digital form, the opinion of the examiner of electronics, referred to in so and so section of the Information Technology Act. Anything? Proof of digital signature, this, you just note down the section 67A, relevant 60. Then, the most important would be section 65B of the Indian Evidence Act is under focus in judicial and law enforcement service. The main points that make are section 65 of the Indian Evidence Act refers to special provisions of the Act in respect of electronic documents. Though section 65 is referred to secondary documents in paper form, there is no such distinction made as to electronic documents. There is no need to distinguish primary and secondary, and all documents need to be interpreted by human beings, which take the form of section 65B. And I think let's go directly to the judgments. Judicial pronouncement. So these are relevant. Judicial pronouncement on relevance and admissibility of electronic evidence. This was in 2018, Union of India and others versus TDR Ravindran V. Desai. 2018, 16, SCC 272. In this, basically, the court emphasized that non-production of certificate under section 65B on an earlier occasion is a curable defect. Even if you not produce section 65B certificate at an earlier stage, it can still be cured. And you can produce it at a later stage, 2018 sure. Whereas in Sonu alias Amar versus State of Haryana, this is 2017, 8 SCC 570. In this judgment, the crucial test as affirmed by the apex court is whether the defect of non-production of certificate could have been cured at the stage of marking the document. If any objection was taken to this CDRs being marked without a certificate, the court would have given the prosecution an opportunity to rectify the deficiency. On the same line. State versus this was also an important judgment that was given. State versus MR Heramat. 2019 3 SCC Criminal 109. In this, the High Court erred in coming to a conclusion that the failure to produce a certificate under Section 65B subclause 4 of the Evidence Act at the stage when the charge sheet was filed was fatal to the prosecution. The need for production of such certificate would arise when the electronic record is sought to be produced in evidence at the trial. It is at that stage the necessity of the production of the certificate would arise. Then on to 2000 P. Gopalakrishnan versus State of Kerala. This is AIR 2020 SC1. In this, the contents of the memory card, pen drive being electronic record must be regarded as a document. If the prosecution is relying on the same, ordinarily the accused must be given a clone copy. In many of the cases, 90% of the cases, the clone copy is never given to the accused. The defendant gets a surprise only when the IO or the particular person who's given that particular statement is, I don't know the way, as public prosecutors, earlier they goes to Lagina because even in my case, when the CCTV footage was captured to stamp the repo, otherwise, had they followed the procedure properly, it was an open and shut case. CCTV footage, witness, pen drive maliko cha, the bungled up when the certificate was given. Because the right person had not given the certificate. The restaurant, the manager who was the certificate here, but they couldn't prove whether he was in control of that system or not, the computer, jam or whatever. Defense CCTV footage. I also never raised this issue before the judge. Last month, I will examine more that CCTV footage for pen drive use. So I was never given an opportunity. So I raised an objection saying, I think Bindu was there in that.
Normally what is done is like, the pen drive is there and it is played in open court. That is what is done. When the person who is given that tube certificate.
I think there are some wherein, the I don't know how fair it is for the defense because defense also should be given an option. You can't then they show the video as a prosecutor. I've seen otherwise, even at this stage when the charge sheet is because the charge sheet file got the you can't deprive the accused goes under 207, they will have to give the entire thing. You can't, as far as you can't deprive the defense of the material that is already, if it's not a part of the case record, then that's something different.
Otherwise, number 4, no?
The contents of the memory card, pen drive, being electronic record, must be regarded as a document.
Okay.
If the prosecution is relying on the same, ordinarily the accused must be given a clone copy thereof to enable her to present an effective defense during the trial. However, in cases involving issues such as privacy of the complainant, witnesses, or his or her identity, the court may be justified in providing only inspection.
That is what
only
is done.
inspection thereof to the accused and his lawyer or expert. But what would come under the definition of being identity?
Like POCSO cases, yes, in all cases.
But normal ways, a clone copy can be thinking, the judgment is there, and this is a judgment of 2020. Because it's a little unfair for suddenly the police expert then cross examine I'll have to take time to examine the thing, कहाँबाट आएको रहेछ, कसरी स्ट्याप गरेको रहेछ, क्यामेरामा के क्याप्चर भएको रहेछ, हो कि होइन भनेर मौका त बोक्नु पर्यो नि त।
तर त्यसमा चाहिँ there are two sides of the coin.
Yes,
also there,
okay.
no? No, that one side is for the pen drive which is not sent for analysis, right?
It can be cloned.
That can be given, I think so.
Yes, त्यही त भनेको क्लोन कपी अगाडि नै थियो।
त्यो चाहिँ दिनु सकिन्छ तर those अब data which has
किन
been sent for
एक्सपोर्ट यो एक्सपोर्टको एभिडेन्स विल ओन्ली बी लिमिटेड टु व्हाट? यो एक्सपोर्टको एभिडेन्स
सबै त पठाइँदैन।
यस ओन्ली बी लिमिटेड टु वेदर दैट के रे क्याप्चर
त्यहीबाट
गरेको टेम्पो गरेको छ कि छैन, यो छ कि छैन, यो छ कि भन्ने हो नि हो। अब त्यहाँ मैले के रे कन्टेन्ट मात्रै उयो त सो I don't think it should think this judgment makes sense also.
No. It has to be dealt as per the cases अब होइन अब as per
You
the
have to have a very
each
strong
case.
reason as to refuse why.
दाजुले भनेको
But
के
this
गर्दा
it says
गरे
this judgment says
त्यो जबरजस्तै हो।
के गरेर चाहिँ 20 वर्ष
हाल्नु पर्ने
म आयो तर अपिल पनि गरेँ नि।
So during the course of the trial, see, once the trial is filed, the trial starts. So normally all the documents, these are supplied to you on the 207, right?
Yeah.
When त्यो गर्दाखेरि चाहिँ प्रुफ कपी
सीसीको टाइममा भनेर अनि बादमा केही छैन भने त त्यसकै बेसमा चाहिँ कुनै केस छ भने चाहिँ इट विल गो द
प्रब्लम त्यही त भयो नि त यहाँ हाम्रो यो जानु म्याडमको कोर्टमा
केस विल गो नि त
what had happened is there was a case of assault. There was a cross case. So the one that I was defending they भन्यो खासमा मलाई हिँड्दा उसलाई नै हिँड्दा रहेछ पुरा हिकाएर अर्को पार्टीले हिकाएर पुरा उयो गरिदिएको रहेछ बट अनफर्चुनेटली दिस गाई ह्याड नो कन्ट्याक्ट्स इन द पुलिस उसको चाहिँ 323 मा मात्रै पर्यो अदर पार्टी वाज अलिकति इन्फ्लुएन्सियल रहेछ पुलिसमा पनि यताउता रहेछ क्रस केसमा उसको चाहिँ अलिकति सिभियर भयो है त्यहाँदेखि के गर्यो भने देन 325 कुनै के लगाएको थियो कि एग्रिगेटेड के असल्ट के गरेर हात भचाइदियो डन्ठाले हिँडाएर भनेर होइन त्यहाँदेखि हात भचाएर त्यो स्टिल पनि लगाउनु पर्यो यो भनेर पुरा डिटेल्स अन्त एक्सरे गर्यो यो गर्यो त्यो गर्यो भने वाट रेकर्डमा एक्सरे नै छैन म त किन उयो गर्नु होइन चुप लागेर बस्यो क्रस एक्जामिन गरिसक्यो राम्रो गरिसक्यो एन्ड इट वाज एट द स्टेज अफ फाइनल हियरिङ suddenly these guys move an application and says कि we want to produce this document court को इसको court में गयो ये रे हाम्रो जमिनमा court में गयो approach the judge and said ये हाम्रोमा त we have a copy of xerox copy of thing X-ray वो यहाँ फाइलै गरेको छ आयो वो सम्म आयो फाइल टेम्परेरी सिम हो X-ray report मेरोमा थिएन X-ray report थियो नि why should I not file it I would have filed it. They must have X-ray गर्यो होला तर हामीलाई बुझाएन हो हामीले फाइलै गरेन X-ray गर्दा साँच्चै नै हात टक्कै भाँचिरहेको छ त्यो भनेको गयो मेरो पेन त होइन हात भाँचिरहेको छ टक्कै हात भाँचिरहेको छ देन दिस गाई सेड म त मणिपालमा गएर के हो यो स्टिल पनि लगाऊ कि भनेर देन आई कल्ड अफ मणिपाल थ्याङ्कफुली मणिपाल आई बीन एडभाइजिङ मणिपाल लिगली फर अ लङ टाइम सो आई टोल्ड देम टु चेक द रेकर्ड कम्प्युटरमा पनि रेकर्ड गरेको छ फेरि यो मान्छेले एडमिट भएर त्यो पनि गरेको थियो गरेको पुरै गरेको थिएँ भरे अनफर्चुनेटली आई डोन्ट नो द आइओ डिडन्ट फाइल इट एन्ड इट इज नट द आइओ फोल्ड पनि होइन यिनीहरू मठे भएर अब के अरे त्यो 100 यताउता भयो होला नि भरे साँच्चै नै भाँचेको रहेछ बट लेटर आई फाउन्ड आउट त्यो हिँडेर भाँचेको होइन भच्चाएर यताउता ठेलठाल गर्दा कि मस्ट हेभ थिङ्किङ तर द कट चाहिँ नथिङ डुइङ They approached me and they moved an application in the interest of justice. If it has not been filed along with Tashi, I will have to allow it. I objected. I look for judgments, but in the interest of ways, you can, at any stage, even when it is listed for final hearing, before that also it can be filed. And the court can allow. त्यसकोमा धन्न अर्जिनल थिएन हो के अरे मिडिएसनमा गएर लास्ट स्टेजमा आई रिक्वेस्टेड द कोर्ट allowed mediation मा मिलायो केस मिलाएर दुईजनाको क्रस केस
गरियो what is the name? You don't know the name.
छ नियम के Robin Gurung and Dr. Surendra.
Leave Rapten this because
The
our
application also
Our
very-
IOs are very mild in doing all these things, no? Not fighting with the okay, but in this case, the object, but they're robbing.
versus state versus Robin Gurung र state versus Dr.
यहाँको केस होइन माथि नै अपिल पनि आएको छैन
Oh,
राइट
अपिलमा पनि त्यो उयो भनेर अपिलमा पनि डक्टर डोमाले राख्थ्यो नि
Doctor के arrested was Oh, yeah.
माथि कति रिजेक्ट गर्थ्यो तल पनि रिजेक्ट गर्थ्यो नि हो त्यो
बहिनी यो के अरे
लास्ट कुरो डक्टर सुरेनले नि उही लिएर 100 कहाँ बचेको छ
okay.
अब मेरो क्लाइन्टले सोध्छु हो यसो भन्नु सर
Before that was before arguments.
Yeah, it was listed of final hearing हैन so I was confident यसको केही छैन अब हैन nothing on record के को grievous यता उता they been able to I think at best they will be able to prove 3 to 3 हो भनेर पछि ओभर कन्फिडेन्ट नि भनेर लास्ट आर्गुमेन्ट को दिन त्यो उही लिएर आउँछ हो सो त्यस्तो पनि हुन्छ
यो पनि धेरै आराकसले बनाएको हाम्रो ओरिजिनल गएको फेरि त्यो सिजनमा
so this Gopal Krishna ko is in a way quite clear which says that no copy should be and in the Tamso Bruno versus Ram Singh it's a very old case 1985 ko it was held that electronic evidence is admissible and provisions under section 65A and 65B of the Evidence Act are by way of clarification and are procedural provisions. You please don't note this. I'll have to check you this date.
1985.
Check this date. And the Yuta, this is a very famous thing. PV versus PV Bashir. 2014 10 SCC 473. It was observed that electronic evidence by way of primary evidence was covered by section 62 of the Evidence Act, to which procedure of section 65B of the Evidence Act was not admissible. However, for secondary evidence, procedure for section 65B of the Evidence Act was required to be followed, and the contrary view taken in Navjot Sandhu versus Navjot Sandhu 2005-11 SCC 600, that secondary evidence of electronic record could be covered under section 63 and 65 of the Evidence Act was not correct. Your PV onward piece is also very important, although all these cases have already been now in that 2022 judgment money, it has already been taken, but then too, I think for reference sake, these cases are very important. Any documentary evidence by way of an electronic record under the Evidence Act in view of section 59 and 65A can be proved only in accordance with the procedure prescribed under section 65B. Section 65B deals with the admissibility of electronic record. The purpose of these provisions is to sanctify secondary evidence in electronic form generated by a computer. Also, this is also very important case, Shafi Mohammed versus State of Himachal Pradesh. This was in 2018, 2 SCC 801. Noticing the 3-judge bench decision in PV Anwar, Anwar PV, have explained the said decision, holding the rigor of the rule there. The secondary evidence of electronic record can only be let subject to the satisfaction of the requirement of section 65B4 to be ameliorated in view of another 3-bench judgments of their lordship in Tamso Bruno and others versus State of Uttar Pradesh. In case where electronic evidence is produced by a party who is not in possession of the device, applicability of section 63 and section 65 of the Evidence Act cannot be held excluded. it is held that the requirement of producing a certificate under section 65B4 as a condition precedent to the leading of secondary evidence of electronic record is attracted when such evidence is produced by a person who is in control of the relative device and not when the device is with the opposite party. Thus, the court clarified the legal position of the subject on the admissibility of electronic evidence, especially by a party who is not in possession of a device from which a document is produced. Such party cannot be required to produce certificate under section 65B of the Evidence Act. In fact, even as a secondary evidence, when say for example I produce something, but I say that I am not in possession of from which computer it was taken on a hard disk, court had given some leverage and said that if you are not in possession of the system, it is not necessary because certificate is not mandatory. Only if the person who is in possession of that particular, say for example, hard disk or computer or mobile, Japanese electronic device, it is mandatory for him to produce that certificate. It's my leverage thing, but all these have been done away with by this latest judgment of Arjun Pandit Rao Khotkar versus Kailas Bhushan Rao. This is Supreme Court who is citation as such, civil appeal number 20825 20826 of 2017. So if you want, I can give the judgment also to live law, but I don't know what it's saying.
provide पनि गरेको थियो जस्तो लाग्यो जजमेन्ट त याद आउँछ
हजुर
हामीलाई यो जजमेन्ट प्रोभाइड पनि गरेको थियो जस्तो लाग्यो बाइ ल डिपार्टमेन्ट
Judgment,
They are
download
strict
live law.
guidelines,
Now all these judgments are
regarding bail in this.
Individually, group of
हाम्रो ग्रुपमा पनि it has been sent. We had a training especially with regard to this.
No, in fact, there are some judgments and some courts have dealt with the situation when bail is being granted.
Yes. And is there
Bail grant got the-
strict guidelines regarding us objecting in bail?
But the courts have said that while granting bail, say for example, I'm at the stage of applying for bail. If these certificates are not produced, it's not necessarily that the certificate has to be produced at the stage of bail release for the hearing. Even if the court is satisfied with the content or the document that is produced in the form of electronic ways, and it could be an email or message or cake or the court can take that into consideration and not strictly think on bail ko stage ma ki where is the certificate exam bhanai parcha bhanne chaina bhanera. I think that there are some rulings. Arjun Pandit Rao ko ke bhanyo with regard to requirement a certificate under section 65B, the position was settled at rest in the following terms. It said that the required certificate under section 65B4 is unnecessary if the original document itself is produced. Now, I think a simple example would be this case. Say, for example, I take a picture from this or do a video recording of this, and I want the recordings, clip of the recordings to be exhibited in the court of law, right? As a PP, the record with this only. But as long as this phone is there in your possession or the phone is there, I produce the phone or you produce the phone, then it is not necessary 65B because the original product of which the image or the video or whatever has been created is in your possession, then I don't think there's a requirement.
The relevant data त्यहीँबाट नै देखाएर प्ले गर्दै भने it's not
It is
required.
not a requirement. They've clearly clarified. This can be done by the owner of a laptop, computer, tablet, or even a mobile phone by stepping into the witness box and proving that the concerned device on which the original information is first stored is owned and operated by him. In case where the computer happens to be a part of computer system or computer network, and it becomes impossible to physically bring such a network to the court, then the only means of providing information contained in such electronic record can be in accordance with section 65B1 together with the requisite certificate under section 65B4, right? The judgment in Tamso Bruno, being per incurium, does not lay down the law correctly. The previous judgment. Also, the judgment in SLP criminal number so and so, you Shafi Mohammed, because prior to the judgment, Shafi Mohammed, all the judgments were being heavily relied by the court in terms of dealing with digital evidence. And the judgment dated so and so do not lay down the law correctly and are therefore overruled. It is necessary to clarify that what is contained in the last sentence in paragraph 24 of Unward PV, which reads as follows. If an electronic record as such is used as primary evidence under section 62 of the Evidence Act, this may more particularly be read without the words under section 62 of the Evidence Act. With this minor clarification, the law stated in paragraph 24 of Unward PV does not need to be revisited. General directions are issued to cellular companies and internet service providers to maintain and other relevant records for a concerned period. I think in this, most of the time, say for example, in situations like, say for example, call records, 65B, but later you realize that 65B of the call record is supposed to be put in place, or computer there's certain images or videos to be certified. But many a times our call records, when there's a time frame, you might say 6 months, it's been deleted, China. But I think the Supreme Court has then issued directions saying, general direction is issued to cellular companies and internet service providers to maintain CDRs and other relevant records for a concerned period, in tune with section 39 of the Evidence Act, in a segregated and secure manner in a particular CDR or other records is seized during investigation in the said period. Concerned parties can then summon such records, so that you can summon such records at the stage of defense evidence, or in the event such data is required to cross-examine a particular witness. This direction shall be applied in criminal trials till appropriate directions are issued under the relevant terms of the applicable licenses or under section 67C of the Information Technology Act. Appropriate rules and directions should be framed as per the IT Act by exercising powers under section 67C and framing suitable rules. Right? So in conclusion, so these are basically the judgments. You think Rahu is the latest judgment which actually deals with all the judgment which has been dealt with previously. Actually, what is it? We can discuss things, no? Senior member also, then there are others. What goes, you'll be knowing, practically, what are the challenges that you think, and we can share, and in fact, some problem that he's facing in his court, you might have dealt with in your court, and or some problem that you're facing, he might have dealt with it in the courts and you, while dealing with you. Digital evidence, electronic evidence, so we can have a really open discussion.
खासै यो 65 people चाहिँ जसले इस्यु गर्छ त्यो मान्छेलाई पनि ट्रेनिङ दिनु पर्छ
हैन अब चाहिँ के रहेछ
भने
आयोलाई चाहिँ मेन्टेन
होइन 65 को दिने मान्छेलाई किन ट्रेनिङ दिनुपर्छ भन्दाखेरि चाहिँ उनले चाहिँ आयोले फरक बनाएर लिएर आउँछ उले साइन गर्छ तर त्यो एक्सट्र्याक्ट गर्ने सीसीटीभी फुटेज बनाएर पेन ड्राइभमा डाउनलोड गर्ने एभ्रिथिङ चाहिँ अर्कोले गर्छ
आयोले सबै जान्छ नि आयोले पेन ड्राइभ अब if you are a witness and you have to provide certain details, why will he buy a pen drive, and why did you go to all this?
अन्त
So IO does everything, takes the pen drive, उसले नै सबै गर्छ, अन्त खालि
साइन मात्रै गर्छ
and he has no idea about what's happening on.
अन्त कोर्टमा आउँछ मैले त साइन मात्रै गरेको भन्ने कस्तो कस्तो सिरियस
मेरो कम्प्युटरबाट लिएर गयो
खासमा चाहिँ उसले आफै निकालेको हुनु पर्यो नि त, उसले त्यसलाई चाहिँ निकालेको हो।
पुलिसलाई एफआइआर गर्यो, पुलिस आयो, पुलिसले के भन्यो, एक्सट्र्याक्ट गर्नु सिसिटिभीको इन द पेन ड्राइभ, मैले आफै एक्सट्र्याक्ट गरेर लगाएँ।
हो त्यही भन्छ त्यो खानचाटाको त्यो उयसको स्ट्यापिङमा पनि त्यही त भयो, पुलिसले भनेछ के अरे फर्स्ट अफ अल उनीहरूको सिसिटिभी फुटेज पनि दिनु, सेकेन्डली पेन ड्राइभमा हालेर त्यो गरेर
65
why should you
that is the process of it. Because police himself cannot go, no, then it has to be extracted by that person only and given.
त्यो हो नि अन्त त यहाँ आयोले गएर खासमा नो बट द आयो क्यान गरेर and the IO cannot be taking it out, extracting त्यो गर्ने
त्यो त गर्नु भएन नि, उसले गर्नु पर्यो।
मैले निकालेको भन्छ नि त।
तर अहिले के भन्छ भने नि
आयोले चाहिँ दिँदै त्यहीबाट ल्याए भन्छ कि
त्यो
तिनी मान्छेले रङ गरेर के हुन्छ त्यो याद हुँदैन, तर जसले सर्टिफिकेटमा साइन गर्यो जसले आएर मैले नै गरेको भन्नु पर्यो नि, उसले अन्डरमा कन्ट्रोल भन्नु पर्यो नि, कम्प्युटर पनि
फेरि उसलाई चाहिँ सबै आयोले एक्सप्लेन गर्नु पर्यो नि, अनअवेयर एज टु वाट इज साइनिङ, वाट इज उनीहरूको लागि एउटा लेम्यानको लागि वाट इज 65B हामीलाई त बुझ्न साह्रो परिरहेको छ।
No, and I think previously, I mean, if you see this Evidence Act 65B for requirement of you certificate university, but I don't think there is a schedule or a proper format. But now, I will run through that also. That new act, deal okay. So I found out that in the new act, there is a proper schedule of the person who's taking it as well as the person who's giving it. Simplified form, and that has to be.
Yeah. Or even me, like my personal case, I have to give your certificate to you. I mean, if you normally just I couldn't find any schedule. Simple form, it's extracted from my mobile, it's just money.
No, in fact, initially I think the investigating officers didn't realize the importance of your 65B.
And they didn't.
They didn't realize. It's like they started doing it in a normal.
भर्खर फाइल गर्दा 65B त भर्खर फाइल
कम्प्लाई गरेकै छैन नि, हाम्रो कतिवटा केस गइसक्यो नि, कतिवटा
They've taken it very casually, like the manner in which they feel this. Okay, you Caesar list. When a Caesar list sign, they don't sometimes they don't.
उनीहरूले बनाएको छ फर्मेट,
एक्चुअली त्यो सिजन मेमो
आयोहरूले बनाएको छ फर्मेट।
सिजन मेमोमा पनि ल्याक्सन लाउनुपर्छ सदर अब कुन चाहिँ ठाउँको स्टेसन छैन त्यो र उता सिजिङ आर्टिकल्सको बाहिर पनि त्यो ल्याक्सन हुनु पर्यो नि, करस्पोन्डिङ हुनु पर्यो,
एकदम सबै हुनुपर्छ। यो त
हुनु पर्यो नि त
गर्छ त्यो गर्छ
अहिले चाहिँ गर्छ, कतिले चाहिँ तर त्यो छोडिदिन्छ, सिजर मेमो बनाउँछ छोडिदिहाल्छ,
कतिले गर्छ कतिले गर्दैन।
त्यो चाहिँ बरु भन्दा के यो पुरानो इन्भेस्टिगेटिङ अफिसर्स हुन्छ नि,
हजुर
हल्दारदेखि आएको के हो दे
हो उनीहरूले गर्छ हो।
डरले चासी नेपाली गाउँछ कस्तो दामी
पहिला साउथमा थियो त
अझै पनि छ। हिजो अस्ति हेरेको एनडिपी नेपालीमा
हाम्रो रोशन राई चाहिँ बलराम राई भन्ने थियो नि, त्यो जोरथाङको कस्तो दामी देख्थ्यो।
होइन हिजो अस्ति पनि आएको छ एनडिपी सिसी गर्नु सबै हेरेको चासी चाहिँ छैन भने नेपालीमा लेखिरहेको छ।
नेपालीमा लेख्नु
मैले जेनरली र फेब्रुअरीमा ट्रान्सलेट गरेको छुट्टीमा
कतिजनाले अस्ति हाम्रो एउटा टाढा गरेको कि दिदी एकदिन
just to के अरे सुन गर्दै के अरे point बढाउँछु कि I'm not going through everything that is thinking of. Just once again, let's run through the judgment. This Section 65B of the Indian Evidence Act is a cornerstone in the legal framework, right, regarding electronic records. Yeah. It details how electronic records should be treated within the judicial system. So let's break down the clauses for a clearer understanding. So what I've done is, खासमा यो बेसिक उयस कम्प्युटर क्लास लिनु त तपाईले म पो जानु पर्यो
हामीले सबले गर्नुपर्छ
ए याद भन्ने गर्दा देख्दैछ
हामी त सानो नि त
फुल पेज चाहिँ कसरी गर्छ
कम्प्युटर सक्दैन
त्यही त यस्तो हेर्नुहोस् ल जस्ट त्यो उयो गरेको छु कि क्लजेस ब्रेकडाउन गरेको छु कि हेर्नुहोस् ल Section 65B1. It marks the acceptance of electronic records as evidence. This clause is revolutionary as it allows for electronic data, encompassing a vast spectrum from emails to digital recordings to be considered equivalent to physical documents in legal terms. 1. Clause B, Clause 2 says, deals with this part outlines the condition that needs to be met for the electronic records to be deemed admissible. It includes stipulations about the regular usage of the computer for lawful activities and the function of the computer during the period of relevance. This is crucial to establishing the reliability of the data. Sometimes to seize it is very important. Even the judgments have time and again said that whether the computer system was operating or not, functioning regularly, state computer was working, state computer was using it. It is important that the system is functioning properly and is in use. Subclause 3, this part addresses the scenario where multiple computers or different combinations of computers have been used over a period for the purpose of storing or processing information for regularly carried out activities. This section clarifies that all such computers, whether operating individually, in succession, or in any combination over that period, are to be treated as a single computer for the purposes of the Act. This provision ensures a holistic approach in considering electronic evidence and recognizing the complexity and variability in modern computer environment. 4. Perhaps the most critical clause for forever that mandate, it is mandatory. It mandates a certificate to accompany the electronic record. This certificate issued by a responsible authority person validates the electronic records and is necessary for its admissibility in the court. Subsection 5 clarifies the scope and definition of information supplied to a computer. It encompasses the following. Say, information supplied in any form directly or indirectly to a computer is recognized. Information supplied for storage or processing in any official activity, even if the computer is operated outside those activities, is considered part of those activities. A computer output is recognized as produced by a computer, whether directly or indirectly. Then judicial interpretations. Although we've already dealt with the cases, the interpretation of Section 55 has been a subject of significant judicial scrutiny, evolving with landmark judgment that shape of its application. अलिकति यसमा different part मैले गरेको छु कि अघि we discussed these cases, but state versus Navjot Sandhuमा, in the landmark case of state versus Navjot Sandhu concerning the 2001 Indian Parliament attack, the Supreme Court ruled that electronic records, particularly mobile phone records, could be admitted as evidence even without a certificate under Section 65B. This judgment was pivotal in recognizing electronic evidence's importance and utility in legal proceedings. I think this was one of the first cases where electronic record in terms of your phone records thing was taken into consideration. Navjot said to go. Then PV who is Bashir Madate, contrasting the earlier stance of Navjot said to, the Supreme Court emphasized the mandatory requirement of a certificate. The Supreme Court said no, nothing doing a mandatory requirement of a certificate under Section 65B4 is required for the admissibility of electronic records as secondary evidence. This judgment understood the importance of compliance. System layer, which is it becomes primary evidence where there is no question of secondary evidence. But secondary evidence, it is certificate is required for judgment. This particular judgment marked a significant shift, bringing forth a stringent approach towards the admissibility of electronic records, aligning more closely with the intent of the legislature when Section 65B was formulated. So, in fact, this cemented the fact that no, the intention of the legislature was so and so. Therefore, it is mandatory as per the provision of the law that a certificate has to be when a secondary evidence is produced. Then in 2008, you are going to Mohammed Waisman, the Supreme Court decision in Mohammed versus State of Uttar Pradesh further nuanced the understanding of Section 65B. In the case, the court relaxed the requirement of Section 65B, subsection clause 4 for certain scenarios. It's not only relaxed, but it said specifically it was held that if an electronic record is produced by a person, okay, we will discuss who is not in possession of the device from which the electronic record is produced, the requirement of a certificate is not always mandatory if you are not in possession. This judgment aimed to address practical difficulties being faced. The court relaxed the terms and conditions a little and said practical difficulties faced by It is not always mandatory that obviously end of the day the court will decide in discretion with the court, but the court took into consideration these practical difficulties and ensured that justice is not denied due to procedural technicalities. The court was a little liberal in this moment thing for Kisma. And then in Pandit Arjunta, this is the latest, it said nothing doing in Pandit the Supreme Court overruled the decision of Shafi Mohammed to an extent. It was clarified that the certificate requirement under Section so and so is a necessity for the admissibility of any electronic record. The court acknowledged the challenges in obtaining certificates, but emphasized the importance of this procedural safeguard to ensure the reliability of electronic evidence. This judgment represents the current position of law regarding the admissibility. So the current position is has been in Arjun Pandit that was passed in the year 2020. Now let's try to decode each subsection. Each subsection of Section 65B serves a distinct purpose in ensuring the admissibility and reliability of electronic evidence. Subsection 1. Brief, one and made it simple. Subsection 1 establishes the foundation for electronic records to be considered as evidence. Subsection 2 provides the criteria for an electronic record to be reliable, focusing on the regular use of the computer and the integrity of data processing. Subsection 3 emphasizes that the continuity and integrity of the electronic records are maintained regardless of the number of devices involved. Subsection 4, with its certificate requirement, acts as a crucial authentication tool, certifying the legitimacy of the electronic records and the process of its creation. And subsection 5 ensures a broad understanding of how information is treated when supplied to a computer, relevant for legal proceedings involving electronic records. And I've just made a flowchart here. This flowchart is just it serves as a valuable tool for understanding the procedural intricacies involved in presenting electronic records in legal proceedings. To enhance understanding of flowchart decline requirement, the flowchart above provides a visual breakdown of the requirements under Section 65B of the Indian Evidence Act for admissibility of electronic records. And
and it systematically outlines. Now, subsection 1 establishes electronic records as potential evidence. Subsection 2 sets the criteria for reliability of these records. Subsection 3 ensures the continuity and integrity of electronic records as maintained, regardless of the number of devices involved. Subsection 4 mandates the certificate requirement for authenticating the electronic records, and subsection 5 gives definition and scope of information supplied to the computer. Now, admissibility of electronic evidence. Now, Indian scenario, and a criteria of admissibility in India. The admissibility of electronic evidence in Indian court is governed by a set of criteria designed to ensure the integrity and reliability of such evidence. These criteria include relevance, it has to be relevant, authenticity, non-tampering, and reliability. Relevance, this is the foundation criterion of an evidence, electronic or otherwise. The evidence must be pertinent to the matter at hand in the litigation. And under the Indian Evidence Act, evidence is deemed relevant if it is directly or indirectly connected to the fact in dispute. Authenticity. For electronic evidence to be admissible, it must be proven authentic. And I use digital electronic evidence, but I think authenticity plays a very important role, because until and unless the prosecution is able to prove that what is being produced before the court and being exhibited is authentic, then this means that the evidence must be shown to be what is purports to be. And for instance, a digital document or an email must be proven to originate from the alleged source. Authenticity proof also. And non-tampering. Given the malleable nature of digital data, it is crucial to establish that the electronic evidence has not been tampered. So this, I think, most of the time is done by way of bringing expert evidence in forensic so as to prove that it is not tampered or altered. The integrity of the data from the time to time of its creation to its presentation in the court must be maintained. Under reliability, the criterion relates to the quality and consistency of the electronic evidence. It must be collected, stored, and transferred in a manner that preserves its reliability. This includes ensuring that the system and the process used to handle the electronic evidence are secure and robust. So, as public prosecutors, I think you can't just rely on the investigating officer. The investigating officer will rely on him until unless you have a very smart and well-aware investigating officers, because end of the day, court must face going. So I think all these instructions need to be to your investigating officers when you are having a thing. Needs to be thing, because end of the day, because of their mistake, it is the public prosecutors who are having a tough time in the courts. Investigating officers, these are like someone was saying, in the High Court, because of the weakness of the defense counsels, especially most of the matters which is being dealt by legal aid counsels. The High Court is observing time and again, on the open court. A prosecution is a sajilo. Now the cross-examine so नसोध्नु भएको क्वेशन सब सोधिरहेको छ क्यो एन्ड आई थिंक एज यङ लयर्स वी गट यस्तो भइसक्यो कि हाम्रो उयसमा बिकज देयर इज नो प्रपर गाइडेन्स नो इभन बी एज अ यङ लयर वी अल्सो फेल द सेम यस्तो भयो कि क्रस एक्जामिन भन्दैमा नि क्वेशन सबै पर्छ एन्ड इट हैज टु बी लङ 10-15 जस्तो क्रस एक्जामिन गर्यो भने वेदर इट्स रेलेभेन्ट or irrelevant they feel like डरलाग्दो काम गर्यो हो अब if a lawyer is sitting, if I see someone cross-examining, and if they just 2 or 3 lines is cross-examined, you know, and finish, more I feel like you beat this.
But
especially young lawyer.
That is enough.
That is enough. Sometimes, you know, you might not even have to ask even one question, and then you know the witness co-evidence might be in your favor. So, I'm not misconception ni. And to got especially you criminal matters, so no so many questions of
सोधेकोले गर्दा नि
डिपेन्ड्स कि कतिजनाको चाहिँ त्यो स्ट्राटेजी नै त्यही हुन्छ कि एन्ड कति सिनियर्स हो बट दे आर भेरी एक्सपिरियन्स उनीहरूको त स्ट्राटेजी नै हुन्छ एन्ड द वे दे प्लेस द क्वेसन्स अब उनीहरूले दे हेभ अ मिन दे इन्टेन्स बट वाट उनीहरूको त्यो स्ट्राटेजीलाई चाहिँ हाम्रो जुनियर लयर्सहरूले चाहिँ दे आर के भनौँ copying it and like they are thinking that they can just go around asking त्यो भनेर त्यो चाहिँ उनीहरूलाई त्यो भएको
definitely help the prosecutor.
High Court of prosecution help हुँदैछ नि. The first thing that they say when they argue the matter is criminal appeal आयो नि. Not it.
That issue is
I want to take your lordship's attention to the cross-examination. Direct cross-examination will start with. So.
I believe that is what, and I believe the court is also saying that the prosecutors are doing the defense को काम and defense are doing the prosecutors को काम. But as soon as
So that's why
even denial पनि त सबै denial गर्नुपर्छ भन्ने छैन नि. Sometimes denial पनि आफ्नो अगाडि
we become a practice कि that's how we've been taught सानो as a lawyer पनि कुनै के नभने सबै deny गर्नुपर्छ अब त्यो.
if you don't deny it, then you are admitting it. So that is
यो त्यो हो त आफ्नै फेभरमा छ डिनाइ किन गर्नु आफ्नो फेभरमा छ भने त डिनाइ किन हुन्छ
they are clear that oh then again त्यो भन्नु
सपोज सिजर त्यसले मलाई कन्टेन्ट चाहिँ याद छैन भने त सकै नि त
त्यो पनि मुनि डिनाइ गर्छ
फेरि डिनाइ गर्छ
त्यो पनि मुनि डिनाइ गर्छ
there have been instances where no defense like you say stop
answer
spoiling your own case. Yeah, keep on doing, you know, because that's what we are there to for proper adjudication of justice. We are not there
the problem is
get a secure and
the problem with us
conviction or
is के रे हामी त्यो हेरेर मात्रै because we don't attend classes. First of all, we don't have the exposure like in the university wherein we don't have this privilege of seeing legal luminaries arguing in the court or variety of cases. That is a bigger courts, even if you have no matters, but the very fact that whole day you sit in the courtroom, you will learn a lot.
तर हैन कि what I feel अहिलेको the young lot they are getting a lot of exposure all thanks to the trainings in this judicial academy money and you got your training.
So the problem is we don't attend, no?
Oh yeah, but see they don't take advantage. Obviously cross examination कसरी गर्नु त्यो हामीले कहाँ पायो त्यस्तो हामी त हाम्रो टाइममा पो बसेर हामीले we used to sit in the court and see हैन तर अहिलेको टाइममा त उनीहरूलाई दिँदैछ like do this do that आजको ट्रेनिङ पनि it was so vital because I don't think so everybody is like हैन technology savvy computer savvy they should have come
online
but they are not taking advantage but that is very sad
effective हुँदैन भनेर रिक्वेस्ट गरेर the judicial academy took note of that. Oh, last one बिचारे हेर्नुस् न अब जजेसहरु
यो चाहिँ खासमा चाहिँ एक्जिक्युटिभ्सहरुले पनि दे शुड कीप अ स्ट्रिक्ट त्यो बसेर चाहिँ टेक एडभान्टेज अफ avail what is given to you.
बोर्डमा पनि त बस्दैन
what happens is when we were executives we started this thing online. In fact we even requested senior lawyers, they were also more than happy to address the bar members. But the only thing is, because it's embarrassing, no? A senior counsel is taking out time and he's ready to address our members. It's very embarrassing.
Because training, whatever it is today, also we came here, we learned so many things. You just you benefits. Even if you take one thing, even if you remember one thing from today, it will help us in the long run. त्यो चाहिँ तर हाम्रो चाहिँ receptive छैन हाम्रो juniors-हरु चाहिँ.
Unfortunately, that we'll have to inculcate in these young minds.
हैन हाम्रो उनीहरुले त हेर्नु कसरी क्रस एक्जामिन अब कसरी क्रस एक्जामिन गर्नु व्हाट क्वेशन त्यस्तोहरुको ट्रेनिङहरु पाउँदैछ उनीहरुले त जस्ट इमेजिन अब हामीलाई त कहाँ त्यस्तो थियो
हामीले हेर्नु पर्यो कोर्टमा बस्नु पर्यो अब्जर्भ गर्नु लेख्नु पर्यो नोट गर्नु पर्यो
अब उपेन्द्र
सिनियरको हेरेर नि त्यहाँबाट त्यो प्याटर्न बनाउनु पर्यो सिजन कसरी एक्जामिन गर्नु
यो चाहिँ यसमा चाहिँ
त्यही हो त्यो नोट गर्नु
अर्काको फलो गर्यो हो
एक दिन बस्यो
हामीले त त्यो केसमा त यस्तो सोधेको त्यही कपी गरिराख्यो अर्को बेला जाँदाखेरि त्यही
that's why the pattern of the question is same
copy paste.
Even so much so the language is also the same.
And we never knew
Same
whether it
language,
was
same
logical
word by
or
word
not.
they say the same thing. Oh,
Anyway.
And for this month, I feel the intervention of the senior councils who have lots of juniors in their chamber, they should make it. They should stress upon intervention is required. You see this training is there, it's for your benefit. Even if you go there and learn just 2 things and come, it is for your benefit. But they should put it across. Normally executives, what can they do? Please go, right, this is the information you are supposed to go. They cannot force them, no? But at least the seniors can coax them up. Senior the chamber senior they have to go. So for instance, that is a very Rapten he sent his juniors, that is a nice approach.
Benefits them, no?
For their benefit, no?
Then coming to all the judgments that we discussed earlier, detailed judgments discussed already, judges judgment. So the key principles established through these judgments are, these judgments collectively have established the key principles in the realm of electronic evidence. Right? One is mandatory certification. Time again, the courts have said that. The necessity of a certificate under section 65B4 for the admissibility of electronic evidence through these judgments. Relevance and authenticity. Emphasis on the relevance and authenticity of electronic records as critical factors for admissibility. If the court is to take those evidence into consideration and place it on record. In practical consideration, the recognition of practical challenges in obtaining certificate and handling electronic evidence. Okay, you have judgment matter that Himachal, no? When the court had taken into consideration practical difficulties, but that's been overruled by Arjun Pandita. It said nothing doing. As long as if it's by way of secondary evidence, there's nothing doing, you have to produce certificate under section 64, 65B. So these judgments can provide a clear chronological understanding of how the legal framework surrounding electronic evidence in India has evolved, and creating a timeline that captures those pivotal cases and their impact on admissibility of electronic evidence in India. Then the UAE, I think it would be repetitive. We've already think significance of Navjot recognizing the admissibility of electronic records such as mobile phone records certification under section so and so. And in fact, let's just see the impact of these judgments one again. Navjot Sanduma, it set a precedent for the acceptance of electronic evidence in criminal cases, highlighting its growing importance in the judicial system. The impact of KB Bashir 2014 cases emphasized procedural compliance and the authenticity of electronic evidence, thereby strengthening the legal framework for digital records. Shafi Mohammed Kaur, the impact was balanced the stringent requirement of the 2014 judgment with practical considerations. It's not one practical consideration wherein the court has to be taken into consideration, which is not mandatory, making the process more accessible. Practical consideration was taken. However, on the latest, where it says impact is reinforced importance of procedural safeguards in the admission of electronic evidence, ensuring the reliability and integrity of digital records in legal proceedings. And with this judgments, section 65, we've dealt in detail, right, along with all the judgments till date in the rulings. Now, I felt what was important was, so you were inquiring about at any stage the same can be filed on error. There's a latest judgment of 2022 judgment, sir. This judgment is, if we want, we can run through that judgment here, and after that, I think how the new law, Evidence Act, the new Evidence Act is going to deal with the section, the electronic evidence code. Section 65B, then I think the section is changed. So that also we will just run through immediately in the end.
वो त्यो यादवले भनेको अब 2023 को जजमेन्ट यादव यहाँ छ के भनेको छैन how many of them?
There are around 16.
16.
Physically, but online also there are.
18 16 plus 2 will
You want me to give the citation of the judgment to you? If there's internet, we can give it.
No, it's there. It's there. I get into their judgment. I think it's important for us to understand. We'll be talking about electronic evidence and courts differentiating the civil and criminal cases. Just run through it. It's a short list. In its interpretation of section 65B, the court also distinguishes the use of certificates in civil and criminal cases. In civil cases, if defective or no certificates are provided, despite a demand made to the concerned authority, the judge conducting the trial should summon the persons mentioned and require them to provide the necessary certificate. Even if there is a defect or if there is, no certificates are provided, if required, the judicial officer can summon the person to provide necessary certificate. This applies when the electronic record is presented as evidence without the required certificate. In such cases, the authority lies with the trial judge. As per the provisions of section 65B4, then with section 207. Okay, we were discussing in 207, and section 311 of the Criminal Procedure Code. Electronic evidence must be furnished no later than before the trial commences. Although it is within the discretion of the court to permit the filing of electronic evidence at a later stage before the trial concludes. It's been think by the judgment as well. However, in the case of CDs, VCDs, chips and similar storage media, they must be accompanied by a certificate obtained at the time of taking the document following the provisions of section 65B. Without such a certificate, the secondary evidence related to that electronic record becomes inadmissible. Okay, we were discussing here, I think Zamil Madam might be able to throw some light, and I'm sure you also must have, as a judicial officer, faced this thing in the court. What we were discussing is in terms of when electronic evidence is placed on record. Say, for example, a video is recorded and then stored in pen drive. Normally, in most of the cases, the practice is that the defense is deprived of this opportunity of even examining until the time when the expert comes and opens it, or for that reason the investigating officer thing. And it is only in the court you get a shock that the video is placed, you don't get an opportunity to take. So, but we discussed a judgment of 2020 wherein the court has said that a clone copy actually can be supplied to the defense so that fair opportunity is given to the defense. So if you as a judicial officer, have you come across anything like that in your court, and how you dealt with it? Have you?
No, I would say defense is not deprived as such, but then when the charge sheet comes with any electronic evidence, so if usually the copy is not made for, I have seen that the copy is not provided to the defense, but then it is normally while framing of the charge and all, so at that time the electronic evidence, say if it is a video, it is played in the court and showed to both the parties, to the accused as well as to the prosecution. And defense can obviously definitely ask for it also. It is not that they cannot ask and the court is not going to provide. They can always ask for it.
At what stage is it shown? CC.
At the stage of CC only it is shown, or before, if while supplying the copy of the case papers, so that time also they can ask for it or it is supplied. Usually it has to be supplied, but if it is not supplied also it can be supplied then and there itself. And if the copy is not made, then definitely at the time of hearing of charge or at any time when the defense, if they ask for it, it is played, or normally court on its own has also
The
played.
technical problem out here is that the expert, sometimes the pen drive is sent to the expert and it comes back. So it is not the expert will come and open. That will be at a later stage.
No, but it can be opened at the court in the
Yes, yes,
presence of both the parties.
that can be done.
At the time of CCD.
त्यो गर्दा हुन्छ किनभने later on again if the defense raises any objection regarding the त्यसको है अब it's open भनेर भन्यो भने त that the
Because the very fact the judgment says a clone copy should be supplied.
Nobody can bar the party from seeing the video or whatever the electronic evidence.
Because what
So
I
it
am
is,
saying
that
also
is-
true, because in front of the presiding officer, both the parties are there. Why should, because,
But it depends
Both
on
of
who
them are
will raise the, because the presiding officer, he or she, Lena after the Bandai, they won't say, so it is up to the party to
Yes, yes,
ask for it.
obviously. Yes.
Then our prosecutors, I don't think so, they will ask.
because like we discussed
The
very
defense, Lena,
okay, I mean discussed very
Most of
because
the time what we do is court ma avene play also, it is usually neither the defense they ask for it, nor the prosecution says anything. Even if the charge is framed without looking at the evidence also, the lawyers, with due respect, but never says anything. But then
yes.
obviously you play the video, if it is something to do with electronic evidence relating case, then definitely the evidence is played in the court.
but in most of the cases, in all courts, we have not played. In the, during the time of CC. त्यति बेला चाहिँ हामीले
त्यो होइन, difference चाहिँ पनि उयो चाहिँ गर्दैन नि त।
And in few cases,
One
we
day
have
but
done.
the
In few cases we have done.
Nobody the, for example, in my case, because I am a judicial magistrate, in my case usually it is relating to theft and all that. So at that point,
That's
I
how it will
play
be.
it in the court, and then it is definitely recorded in the order sheet that the sealed envelope was opened and the pen drive was played before the open court in presence of the party.
That makes sense, no? Because okay, Bhupenले भनेको जस्तो
खासमा चाहिँ हामी चाहिँ we were in the notion that like the as it is sent the export
is only to the extent that whether it's been is a fabricated thing or not, whether it's been tampered. त्यो मात्रै हो त। उसले त त्यो authenticity of that उयसबाट गरेको हो कि हैन, whether that correct हो कि हैन, त्यो त भन्न सक्दैन नि त। His is only to the extent
But
to
with
prove that whether it's
regard
been
to
tampered or not.
the, but with regard to the identification of the, say for example, there is just one pen drive.
चार्ज सिटको टाइममा त प्राइमा फेसी मात्रै त हेर्छ नि, त्यति बेला त हो कि होइन अरू त एकदमै प्रुफ यही हो त भन्दैन। सो प्राइमा फेसीमा त जे एभिडेन्स अन रेकर्ड छ मटेरियल त्यही हेरेर त प्राइमा फेसी गर्नु पर्यो।
तर फेरि त्यो आइडेन्टिफिकेसनमा म्याम फेरि अब 2-3 पेन ड्राइभ छ भने the expert has to come and say that this is the matter is in this pen drive, in this pen drive भनेर एक-एकवटा उनले नै देखाउँछ नि त। सो हामीलाई पनि याद हुँदैन। सो त्यो चाहिँ अब अलिकति ट्रिकी नै भइजान्छ होला त्यस्तो।
नराम्रो भन्दा जस्तो डिफर्मेसनको केस या त्यस्तोमा
त्यस्तोमा चाहिँ अब
प्ले द पेन ड्राइभ एट द टाइम अफ तर अरू केसमा त बाद नखोल्नु
होइन त्यो तपाईँहरूमा जुनै पनि केसमा इलेक्ट्रोनिक एभिडेन्स त चाहे वेदर इट इज इलेक्ट्रोनिक or whether it is a documentary evidence or anything, you can see it anytime, no? It is up to you. So just because it is electronic भनेर मात्रै त्यो चाहिँ हेर्नै पाउँदैन त भन्नु सक्दैन नि। एभिडेन्स इज एभिडेन्स।
Because only in sensitive, okay, the judgment, so only in sensitive material, the sensitive which cannot be seen, then only is a dissuasion of the judicial officer.
you can play it, but you cannot. The copy of the same cannot be provided to the parties because it may be misused. So identity, with regard to identity.
In fact, I was reading a judgment yesterday night, late and I was reading a judgment. In these kind of thing, where in electronic, in some of the courts, the judges have even, approached the High Court and said, especially female judges, when it comes to examining these sexually waste to content devices, saying that she will not be in a position to deal with the case properly, or it will be a little awkward to be enemy. Matters have been, judges have recused themselves, and some of the judges have also been appointed. Versus T-Nasib
के भन्नु त
State of Karnataka versus
T-Nasib
T-Nasib alias Nasib alias
NASIR
NASIR
alias
alias
कति दिन
Thandi Navita. We elected 2023. This is live law SC 965. SC yeah, you report also. And now criminal appeal number 3456 of 2023. So where it says that section 65B might deal with a certificate under section 65B of the Indian Evidence Act to prove electronic evidence can be produced at any stage of the trial. A certificate under section 65B of the Evidence Act to prove electronic evidence can be produced at any stage of the trial. In fact, the Karnataka High Court had refused. The Supreme Court said nothing doing. You can at any stage because this was related to Karnataka or Bangalore blast. Okay. Then it says it deals with section 311, Indian Evidence Act 1872, section 65B. Fair trial in a criminal case does not mean that it should be fair to one of the parties. Rather, the object is that no guilty should go scot-free and no innocent should be punished. A certificate under section 65B of the Act, which is sought to be produced by the prosecution, is not an evidence which has been created now. It is meeting the requirement of law to prove a report on record. Therefore, by permitting the prosecution to produce the certificate under section 65B of the Act at this stage will not result in any irreversible prejudice to the accused. The accused will have full opportunity to rebut the evidence led by the prosecution. This is the purpose for which section 311, under section 311 CRPC is there. The object of the code is to arrive at truth. However, the power under section 311 of CRPC can be exercised to subserve the clause of justice and public interest. In the case in hand, this exercise of power is required to uphold the truth and no prejudice as such is going to be caused to the accused.
तर यसमा चाहिँ अलरेडी नै हालिसकेको थिएछ नि त त्यो चाहिँ whatever is required to be proved, the material was there.
No, obviously, but
material was there, but the certificate was
yes, certificate. When the material is there, obviously as secondary evidence to prove it, prove that thing, it has to be obviously. Many a times
CCTV footages or
phone records thing, you normally tend to ignore me, but the court has said, very often use goes on. So
the defense are going to boycott you. भन्नु कि नभन्नु
त्यहाँदेखि नि we will let's tally अहिलेको with because from July 1st onwards we'll be dealing with the new evidence act. So it's been dealt a little extensively in the new act.
Bharatiya Sakshya.
admissibility of electronic evidence under the Bharatiya Sakshya Adhiniyam. BSA. So difficult to pronounce.
We get used to it.
BSA, तर कसो भनौँ?
Last
My
one.
lords, under the Bharatiya Sakshya Adhiniyam,
We get used to it now.
under the BSA. Under the B, some of the judges are taking Mati, I got sometimes. You never know what kind of judges you want to sit in. What is BSA? Very important. What is IPC? Full bonu bhancha ni हैन Indian Bureau bhancha. What is BSA? Bharatiya Sakshya Adhiniyam. So the Bharatiya BSB BSA
अधिनियम
includes electronic and digital records in the definition of documents, right? This definition now covers a diverse range of electronic records, including emails, server logs, files stored on computers, laptops or smartphones, text messages, website contents, location data, voicemails, and messages stored on digital devices. More extensive. So, treating electronic evidence at par with primary evidence. This law deals with it. Section 61 of the BSA states that nothing in this adhiniyam shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it is electronic or digital record. And such records shall, subject to section 63, have the same legal effect, validity and enforceability as other documents, as per the new act. This section treats electronic records at par with documentary evidence, as already treated under the Indian Evidence Act of 1872, as amended by the Information Technology Act of 2000. The new act under section 57 defines primary evidence and carries 4 explanations, named 4, 5, 6 and 7, in addition to the 3 explanations mentioned in IEA. With the electronic evidence based, there are 3 definitions, they have added 4 more. According to the new act provisions, electronic or digital records will be treated as primary evidence in the following 4 circumstances. Explanation 4 states that where an electronic or digital record is created or stored and such storage occurs simultaneously or sequentially in multiple files, each such file is primary evidence. Explanation 5 states that where an electronic or digital record is produced from proper custody, such electronic and digital record is primary evidence unless it is disputed. Explanation 6 must state that where a video recording is simultaneously stored in electronic form and transmitted or broadcasted or transferred to another, each of the stored recording is primary evidence. Then 7 where an electronic or digital record is stored in multiple storage spaces in computer resources, each such automatic storage, including temporary file, can be considered as primary evidence. Addition to the definition of document and evidence. The new act now defines document as document means any matter expressed or described or otherwise recorded upon any substance by means of letters, figures or marks or any other means or by more than one of those means, intending to be used or which may be used for the purpose of recording that matter and includes electronic and digital records. Thus, the new law considers electronic and digital records under the definition of document, which was not a part of the Indian Evidence Act. Further, new illustrations 6 added to the definition of documents to account for electronic records. And electronic records on email, server logs, documents on computers, laptops or smartphones, messages, websites, locational evidence, and voicemail message stored on digital devices are now considered documents under the will be considered document under the new act. Similarly, the new act made an addition to the definition of evidence, which shall include information given electronically within oral evidence or digital records within documentary evidence as not proved under the Indian Evidence Act. All these definitions also, I'm sure they might create a lot of confusion because it depends on how the courts are going to interpret it. Was there, you want fine judgments, so this will obviously
there will be two interpretation.
All depends on it. Expanding the reach of electronic evidence, it's been expanded. The new act introduces significant modification in the realm of electronic evidence, bringing about substantive change alongside primary and secondary evidence considerations. Section 63 of the new act expands its reach to electronic records in semiconductor memories, in addition to those on paper and stored, recorded, copied in optical or magnetic media. Right? Furthermore, the provision extends its applicability to encompass any communication device, broadcasting its scope. Subsection 3 of the proviso, the provision defines the definition of a computer or a communication device, providing it with a more comprehensive interpretation. And the conditions of mandatory production of certificate detained but requires approval from an expert too. Now it says, it is important to note that subsection 4 of the new act, section 63, maintains the mandatory requirement of a certificate as spelled under section 65B of the Old Act, but specifies that the certificate must be submitted along with electronic records each time electronic record is presented before the court. Now, whether this judgment 2024 will be relevant or not once the new act comes into existence, because it says, but specifies that the certificate must be submitted along with electronic records each time electronic record is produced before the court. Additionally, the revised proviso clarifies that the certificate can be provided by any person in charge of the computer or communication device and an expert, whichever is appropriate, replacing the previous requirement for a person occupying a responsible position. Earlier act only the person who is just in responsible position, who is in possession of that system can enable, isn't it? But the new act, revised provision, certificate can be provided by any person in charge of the computer or communication device and an expert, whichever is appropriate.
You say in terms of like call detail cause or that your company के सबै main मान्छे आउनुपर्छ नि त हो अब चाहिँ no anybody can do like technical staff
whosoever is in charge, but he has to do his thing. अब कस्तो पाराले इन्टरप्रेट गर्छ
हामीले चाहिँ त्यस्तो पाराले इन्टरप्रेट
And the introduction of format for production of certificate. This is the most important, I think, would be very helpful for everyone, including the
investigating agencies like
While the IEA did not specify the form of certificate to be produced for the proof of secondary evidence and is often presented as an affidavit in practice, however, the section 63(4) subclause C of the new act introduces Schedule A and B for this purpose. Part A needs to be filled by the party producing the electronic records, output of the digital record, and Part B needs to be filled by an expert to submit that the hash value of the electronic digital record is produced from the given algorithms in the form itself. Details of that. Now, let me just share that certificate as well. Certificate, new format, certificate pani. Esto para act my detail. I don't know how. Costo para jaya
तर कुनै के दिनु भन्छ बाइ एक्सपोर्ट चाहिँ
I so and so employed at this do hereby solemnly
To be fulfilled by the
submit as follows. The procedure electoral record or digital record are obtained from the following device. Use it right? To be filled by the expert.
Part B हो एक्सपर्टको मात्रै छ होला
होइन, होइन, यहाँ छ नि।
ए, हुन्छ।
To be filled by parties. I, so and so residing, right? Sincerely state and submit as follows. I have produced electronic record, output of digital record taken from the following device. I have produced, the one who's producing. Computer, storage, DVR. And this could be, I think, by the investigating officer, or for that reason in civil suits, or KEMA, if I am, or a private company, if I am submitting as a private party or in civil suits ma the state this can be used as well as for the prosecution. I think the investigating officer needs to use this.
Or the person, the witness who is giving the...
The device was under the lawful control for regular editing, so it's been made easier. Thank you. Part B ma chai यो चाहिँ कसरी अब गर्छ है फेरि ह्याश भ्याल्यु इलेक्ट्रोनिकली अब त्यो
यो चाहिँ झमेला भएछ नि त झमेला
particular device for identity.
आइडेन्टिटी
त्यो के जस्तै IMEI
जस्तो मोबाइल कम्प्युटरमा IEMI
त्यो त होइन निक्लिहाल्छ त कुनै के किसिमले भनिन्छ हैन
सिस्टममै दियो No, I think if it is your computer, no, then obviously the very fact that you are the responsible person in charge of the computer, after computer we have to mobile को use होने your
त्यसमा पनि you have to press something and it comes भन्छ नि पहिला त्यसमा चाहिँ IMEI मलाई कुनै के press मलाई त बिर्सिनु There is a process. I mean, it's difficult for us, but for technical.
We'll learn.
अब यो गरेर पनि त्यही त भनेको अब जुलाई उयस देखि पनि
गर्नै पर्ने रहेछ
मोरलेस त्यहाँदेखि त्यो 65 B को बदली पनि 63 के there has to be and only once cases start getting registered and you face it in the court, then only you will know the practicalities of it. But the principles of this can always be taken into consideration.
Yeah.
Oh, principles you will have to follow this. So, okay.
The spirit it is the same, no?
Yeah. Our confusion was after this, if you see the judgments as well, some of the court says no, it has to be.
What did happen to all this POCSO Act and all? Only the
It is only the
manual, the code.
The code.
Everything died by CRP.
अर्कै भन्नु त पर्दैन होला
अस्ति सौदिनमा एकजना जज अघि उहाँले भने जस्तो म यो भन्न जान्दिनँ भनेछ कि अन्त त्यसमै इस्यु भएर
भन्नै पर्ने नि हो त अब अधिनियममा
साउथ इन्डियामा चाहिँ यो भन्नु भने प्रोनाउन्सिएसन मलाई आउँदैन भनेर भन्दाखेरि चाहिँ
हुँदै रहेछ अन्त त्यो के बिहार हो कि कहाँ हो I think the judge is South Indian. So the council starts making submission in Hindi. Right?
I've seen that video.
He says, why are you speaking Hindi? I don't understand. राष्ट्रिय भाषा है You make your registry.
I don't know English on this.
Coach right to lawyer right to end of the day it is the judge who passes to you can't just be just for the sake of confronting what the judge is saying also right here. How can I decide? If I don't understand, if I don't have clarity on the submission that you're making, how do I?
Both of them are correct in their own
Think you, but
the software.
But he could have just transferred it to some other court saying.
That's what it
So it might not be
proper
fair on my part, because I might not be.
Then what happened eventually?
Discussion.
was here in YouTube.
As we come to the end of today's program, I'd like to thank you all on behalf of Sikkim Judicial Academy. First of all, I'd like to thank Mr. Tashi Barfungpa, learned advocate, High Court of Sikkim, for gracing us with his presence and delivering on today's topic. I would like to thank all the learned public prosecutors who have joined us on today's topic, keeping aside all of their valuable works. I must also thank learned Deputy Director Madam for guiding us to conduct today's session. And lastly, I would like to thank all my colleagues who have worked behind the scenes to make this program a success. Thank you all.